Welcome back to the deep dive. Today we are going to ruin your day, but in a productive way.
That's always the goal.
Right. We are stepping into the absolute worst part of the work week, which is the toxic boss. I mean, we all have stories, right?
No, definitely.
The passive aggressive emails, the public shaming, the weird power trips. But today we aren't just venting about it. We are looking at the legal razor wire that separates, my boss is a jerk from my boss just committed a tort. We're talking about negligent infliction of emotional distress, or NIE, specifically in the workplace.
Yeah, it's a really messy area of law
Yeah.
because it sits right at this violent intersection of psychology, employment rights, and tort law.
Yeah.
It forces the courts to answer a really uncomfortable question.
Which is,
Basically, in a capitalist society, how much abuse are you legally required to absorb in exchange for a paycheck?
and to answer that, we are looking at a case that is, honestly, it's one of the wildest things I have ever read.
It really is.
It's called Frogley v. Meridian Joint School District Number 2. This is from the Idaho Supreme Court in 2013. And let me just warn everyone listening, the facts in this case are not your standard, my boss yelled at me situation.
Not at all.
We are talking about fake wedding announcements involving tramps, public speculation about sex lives, and school administrators literally behaving like mean girls in a teen movie.
The facts are incredibly visceral, shocking even. But the legal tension underneath those facts is what really matters for us today.
Because of the jurisdiction.
Exactly. We are dealing with Idaho, which has a very unique minority approach to emotional distress. They remove some of the physical barriers to suing, but they replace them with incredibly strict mental hurdles.
Okay, so lay out the map for us. How are we dissecting this train wreck?
We have a very specific analytical path today. First,
Yeah.
we need to define the elements of NID in Idaho to understand the rules of the game. Second, we have to look at the social hardening doctrine.
Which is what exactly?
It's basically the law's demand that you grow a thick skin.
Ah, got it.
Third, we will look at the susceptibility exception to that rule, using a specific hypothetical to make it stick. And finally, we will do a rigorous elemental analysis of the Frogley case itself to see exactly why the Supreme Court had to step in.
All right, let's get into the doctrine. I know negligent infliction of emotional distress sounds really fancy, but break it down for us. What is the foundational black letter law here? Like, what is the general rule for this in Idaho?
The general rule in Idaho requires 5 specific elements to establish a claim. It is a strict checklist. If you miss even one, you lose.
Okay, what are they?
First, a legal duty recognized by law. Second, a breach of that duty. Third, a causal connection between the conduct and the injury. Fourth, actual loss or damage.
Mm-hmm.
And fifth, and this is the one that trips everyone up, there must be a physical manifestation of the emotional injury.
Hold on. Physical manifestation.
Yeah.
So if I'm, say, clinically depressed because my boss is tormenting me every day, but I don't have a rash or a tremor, I have no case.
Generally speaking, yes. The law is incredibly skeptical of mental harm. It's invisible, right? It's easy to exaggerate.
I guess that's true.
So the courts demand a physical receipt. They want a guarantee of genuineness. You can't just say, I'm sad. You need medical evidence of a physical reaction. Nausea, heart palpitations, severe weight loss, something tangible.
That feels incredibly archaic. But you mentioned Idaho is a minority jurisdiction, so how does this differ from the rest of the country?
Well, most jurisdictions follow what's called the zone of danger rule.
Which totally sounds like a Top Gun reference.
It does, but I promise it's much less cool. In most states, say New York or California, to sue for negligent emotional distress, you have to be in immediate risk of physical harm.
Give me an example.
Imagine you're walking across the street. A drunk driver swerves, misses you by 2 inches, but hits the person right next to you. You weren't physically hit, but you were in the zone of danger. You genuinely feared for your life. That fear justifies the lawsuit.
Okay, so in the majority of states, I need to almost die to sue for this.
Usually, yes, but Idaho removed that requirement entirely. They said, no, you don't need to be almost hit by a car. You can sue for emotional distress even if you were sitting completely safely in an office chair the whole time.
That sounds easier, like a lower bar.
You would think so, but because they lowered the gate on the zone of danger, they raised the walls on everything else. Specifically, they made the standard for foreseeability sky high.
Because there's no physical danger to look at.
Exactly. Since there is no physical danger, the court has to determine, was it truly foreseeable that words alone would cause this person to physically collapse?
Which brings us to this social hardening concept you mentioned. I've heard this called the thick skin standard. Is the law really just telling me to, man up?
In a way, yes.
Yeah.
The general rule is that there is absolutely no duty to be polite. The courts, citing the Restatement Second of Torts, hold that the law expects people to be hardened to a certain amount of rough language.
That seems absurd. I mean, if I scream at you every single day, surely I know I'm hurting you.
You might know you're annoying me or upsetting me, but the law says insults are not a foreseeable cause of serious physical injury.
Why not?
The reasoning is judicial economy. Think about it. If everyone could sue every time their feelings were hurt at work, the court system would completely collapse overnight. So the rough edges of our society are just something we have to endure.
So the baseline is you have no duty to be nice to me, and I just have to tolerate your rudeness.
Correct. That is the default state of the law.
But obviously people do win these cases. We're talking about one today. So there has to be a backdoor.
There is. It is the susceptibility exception. Liability arises if the conduct causes harm to a susceptible or frail individual. And this is the critical part, the defendant was aware of this condition.
So knowledge changes the rules.
Exactly. Knowledge creates the duty.
I want to nail this concept down because it really feels like the pivot point for everything. Can you give us a hypothetical? Not the case facts yet, just a visceral scenario to illustrate this susceptibility plus awareness dynamic.
Absolutely. Let's look at the arachnophobia boss hypothesis. This is the cleanest way to view it.
Okay, I'm listening.
Imagine you have a boss, and this boss knows that years ago you were hospitalized for a severe panic attack after a spider bite. You have clinical, documented arachnophobia.
Okay, so the boss has awareness of my susceptibility.
Right. Now imagine this boss thinks it would be hilarious to leave realistic rubber tarantulas on your office chair every single morning.
That's just cruel.
It is. And as a result of finding these spiders day after day, you have a literal heart attack from the sheer compounded terror.
Wow. Okay.
So, under the general rule, putting a rubber spider on a desk is just a dumb prank. It's a rough edge of society. But because the boss had knowledge of your specific susceptibility, the serious physical harm, the heart attack, became completely foreseeable.
And that creates the liability.
Yes. The knowledge transformed a crude prank into a breach of duty. The boss had a legal duty to refrain from that specific conduct because he knew you were fragile in that specific way.
That makes perfect sense. The notice essentially weaponizes the conduct.
Exactly. Keep that arachnophobia boss in your head. Because in Frogley, the phobia was Frogley's mental state, and the rubber spiders were the daily harassment.
Let's get to that. Let's analyze Frogley v. Meridian Joint School District Number 2. First, what are the legally dispositive facts?
Wade Frogley was an assistant principal at Mountain View High School. He was a newly hired administrator. The defendants were the school district itself and his direct boss, Principal Aaron Maybon. Almost immediately after Frogley started, he claimed the administration began a coordinated campaign to destroy him.
Give us the details. What exactly were they doing?
It started with a document slid under his office door. It was a fake wedding announcement. It featured a picture of a scantily clad bride, and Frogley's face was photoshopped onto the groom. The text literally announced the wedding of Wade Frogley to a cheap 2-bit tramp.
Wait, this is a high school? Was this a student prank?
You would hope so. But no. Principal Maybon actually admitted that his own secretary prepared it and delivered it. This came from inside the main office.
That's wildly unprofessional. But is it a tort?
Well, that was just the opener. During lunch supervision, Maybon and other school administrators would sit together. They allegedly made daily comments about Frogley's food. Specifically, because he had a lot of food on his tray, they joked loudly that he must be exchanging sex for food with the lunch servers.
Sex for food. These are grown men. These are educators.
It gets much darker. They openly referred to Frogley's office as a nest of whores.
A nest of horrors in a high school.
That is the formal allegation. They also publicly speculated about his sexual orientation, his dating life, and whether he was leaving school grounds during the day to have illicit sex. This was a daily, relentless barrage.
Okay, so we definitely have a hostile environment. But based on what you told me earlier about thick skin, isn't this technically just rough language? Sticks and stones?
Initially, yes. But here is the turning point fact. On November 5th, Frogley met with Principal Maybon behind closed doors. He didn't just sit there and take it. He emphatically demanded that the comments stop.
Sure.
He told Maybon, "This is affecting me. I am distressed. Stop it."
He gave notice. He told them about the spider phobia.
Precisely. And what happened next is the key to the whole case. Maybon didn't apologize. He retaliated. Immediately after that November 5th meeting, Mabon started tracking Frogley's minutes. If Frogley was 3 minutes late to the cafeteria for duty, he got written up. If he missed a minor meeting, a formal letter of reprimand. This intense scrutiny started only after he complained.
And did Frogley break? Did he have that physical manifestation you mentioned
He
earlier?
did. He sought medical treatment for severe depression and anxiety, and he had the medical records from his doctors to prove it.
So he sues. And this is where the procedural stuff really matters. The district court, the lower court, granted summary judgment for the school. For the non-lawyers listening, what does that actually mean?
Think of a football game. Summary judgment is the referee walking onto the field right at halftime, blowing the whistle and saying, "Game over. Home team wins."
They don't even let them finish the game.
No. The judge basically looks at the plaintiff's case on paper and says, even if everything you say is 100% true, the law cannot help you. There's no need for a jury trial because you have no legal leg to stand on.
So the lower court looked at the nest of horrors comment and the fake wedding announcement and essentially said, so what? That's legal.
Essentially, yes. They ruled that Frogley didn't overcome that thick-skin standard. They said it was just workplace incivility. So Frogley appealed that decision to the Idaho Supreme Court.
And what was the core legal issue?
The specific issue is whether the defendant's conduct created a foreseeable risk of serious harm sufficient to survive summary judgment, given the requirement that employees must usually endure rough language in the workplace.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the Idaho formulation of negligent infliction of emotional distress. As we outlined earlier, this rule has 5 distinct elements. 1, a legal duty. 2, a breach of that duty. 3, causation. 4, actual loss. And 5, physical manifestation of the injury. However, the controlling principle here was the exception to the duty rule.
It is.
While verbal abuse is generally not a breach of duty, a duty does arise if the defendant is aware of a plaintiff's specific susceptibility to emotional distress.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, duty and foreseeability?
This is exactly where the arachnophobia analogy comes into play. The sub-issue here was the harm actually foreseeable?
Right.
The sub-rule is that a duty exists only if harm is foreseeable. Under the thick-skin doctrine, insults are usually not foreseeable causes of serious harm. However, once a defendant has knowledge of susceptibility, the harm becomes foreseeable.
So how did the court apply that to Frogley?
The court zeroed in on that November 5th meeting. Frogley explicitly told Mabon the conduct was hurting him. He put them on formal notice. So the court's conclusion on this element was that after that meeting, the defendants were no longer just joking around. They were knowingly inflicting distress on someone who had already claimed injury. That knowledge created the legal duty to stop.
Understood. Now what about the second element, breach?
For breach, the sub-issue is, did the defendants fail to exercise ordinary care? The sub-rule asks if the conduct fell below the standard of a reasonable person.
And the application.
The evidence showed that the sexual comments and the nest of horrors remarks continued after the complaint. And even worse, Mabon began the hyper-scrutiny of Frogley's schedule as a form of direct retaliation.
He doubled down.
Exactly. So the court's conclusion on breach was that a reasonable jury could find that continuing to harass an employee after they have begged you to stop far exceeds the rough edges of society. It wasn't just rude anymore. It was a clear breach of the duty of care.
And regarding the requirement for the fifth element, physical manifestation.
The sub-issue here is whether Frogley proved the injury was genuine. The sub-rule in Idaho is that emotional injury alone is insufficient. There must be physical symptoms.
Right, the receipt. So how did he apply the facts here?
Frogley provided actual medical records showing clinical treatment for anxiety and depression. So the court concluded that this was enough to create a genuine issue of material fact. It satisfied the element because it proved the harm wasn't just imagined or exaggerated.
And after analyzing all the elements, what was the court's final conclusion?
The Supreme Court of Idaho reversed the district court's grant of summary judgment. They held that because Frogley complained and the harassment continued anyway, a jury could absolutely find that the school was negligent. They sent the case back for trial.
So the referee blew the whistle and said, actually, put the players back on the field. We're finishing this game.
Precisely. The game goes to a jury.
That is a massive turnaround. But it really highlights how fragile these cases are, because if he hadn't gone to the doctor or if he hadn't had that November 5th meeting, he just loses.
Exactly. Without the meeting, there is no notice. Without notice, there is no duty. And without duty, there is no case. It falls apart completely.
Okay, let's synthesize this. We have a lot of listeners who might be law students or HR professionals or honestly just people trying to survive a bad boss. If they encounter a situation like this, how should they analyze it? Give us the diagnostic framework.
If you are spotting this issue on a law exam or evaluating a real-life situation, you need to run this strict four-step diagnostic checklist. Step 1, check for the zone of danger. First, look at the jurisdiction you're in. Does it require a risk of physical impact?
Like California or New York.
Right. If yes, and there was no physical danger, like you were just sitting at your desk, the case is dismissed. If no, like in Idaho, you proceed to step 2.
Which is?
Step 2, verify physical manifestation.
Mm.
Is there medical evidence? You have to look for treatment for anxiety, nausea, ulcers, heart issues. If it's just hurt feelings with no medical backup, the case is dismissed.
Got it. Step 3.
Step 3 is analyze the conduct. This is the thick skin check. Is the behavior just rude, insulting, or mean? If yes, generally there is no liability. The law essentially says grow up.
And the final step.
Step 4 is the susceptibility override. This is the arachnophobia rule. You ask 2 questions. Did the plaintiff inform the defendant that the conduct was harmful? And did the defendant continue anyway?
And if the answer to both is yes.
If yes to both, the thick-skin defense completely fails. Foreseeability is established, duty is triggered, and you have a viable claim for NIE.
That step 4 is really the killer, because it essentially says the thick skin doctrine has an expiration date, and that date is the exact moment I look at you and tell you to stop.
Correct. It powerfully shifts the legal burden from the victim right back to the bully.
So the key takeaway here is, in the eyes of the law, you have to be tough, but you do not have to be silent. Once you speak up, the legal landscape completely changes. But here is the dark cloud I want to end on. What does this practically mean for an employee?
It creates a really dangerous paradox. To win the lawsuit, Frogley had to speak up. He had to demand they stop to trigger that legal duty. But in the real world, what actually happened when he spoke up?
They retaliated. They started writing him up for being 2 minutes late to lunch duty.
Exactly. The formal action required to save your legal case is often the exact same action that puts a massive target on your back in the office.
It's also just disturbing to think about the alternative. The court implies that without Frogley's emphatic demand to stop on November 5th, the nest of whores comment might have been considered perfectly legal, just the rough language of society.
It raises a very provocative question about the morality of our legal system. Does the law essentially give workplace bullers a free pass to psychologically torture people right up until the exact moment the victim formally objects?
Wow.
Because if you look at the mechanics of this ruling, it seems the legal clock on negligence didn't even start ticking until Frogley finally screamed, "Stop."
That is a terrifying thought. That silence isn't just consent. In the eyes of the law, silence is literally permission to be abused. Deep dive complete.